Good day, this is Petervan Bajao for Chapter 5, Law on Sales, Agency, and Credit Transactions. By the conduct of sales, one of the contracting parties obligates himself to transfer ownership and the other to pay a certain price of or money in its equivalent. Like any other contracts of sales also has essential elements. This is what we call COC, consent, object, and cause. Consent when there is a meeting of minds to transfer ownership in exchange of the price, while object, the determinate thing to be delivered, and cause, the price certain in money or its equivalent. Apart from the essential elements, it also has natural elements and accidental elements. Natural elements refers to that if there is no warranty against hidden defects or warranty against eviction, the law presumes that there is. Accidental elements, on the other hand, refer to the stipulations agreed upon the parties, such as those pertaining to the terms and manner of payment, penalty, interest, and other conditions governing the contract of sale. Characteristics of contract of sale: consensual, meaning it is perfected by mere consent. Bilateral, the parties are bound by their reciprocal obligations, such as seller to deliver and transfer a determinate thing, buyer to pay the price. Commutative, meaning the parties exchange almost equivalent values. Principal, its existence does not depend upon another contract. Onerous, the parties give invaluable consideration in order to acquire rights and nominate if the law designates a special name to it. How about the form of contract of sale? Does it have to be written? In the general rule, a contract of sale may be made in writing or by word or mouth, or partly in writing and partly by word of mouth, or may be inferred from the conduct of the parties. Exceptions from this rule: if the law requires a document or other special form, the contracting parties may compel each other to observe that form according to Article 1357 of the NCC. Second, under the statute of frauds, certain contracts must be in writing, otherwise they shall be unenforceable, according to Article 1403. Sale of large cattle, which requires that the same be recorded with the city or municipal treasurer and that a certificate of transfer be issued, otherwise the sale is not valid, according to Article 1581. In the ending part of the article, it is stated that a contract of sale may be absolute or conditional. A sale is absolute when no condition is imposed and ownership passes to the vendee upon delivery of the thing subject of the sale, while conditional sale is when the sale contemplates a contingency and in general where the contract is subject to certain conditions, usually in the case of the vendee, the full payment of the agreed purchase price; in the case of the vendor, the fulfillment of certain warranties. Contract to sell: a bilateral contract whereby the prospective seller, while expressly reserving the ownership of the subject property despite delivery thereof to the prospective buyer, binds himself to sell the said property exclusively to the prospective buyer upon fulfillment of the condition agreed upon, that is, full payment of the purchase price. Now we have a question: is a contract to sell the same as a conditional contract of sale? The answer is no. A contract to sell may further be distinguished from a conditional contract of sale in that the fulfillment of the respective condition, which is the full payment of the purchase price, will not automatically transfer ownership to the buyer. Although the property may have been previously delivered to him, the prospective vendor still has to convey title to the prospective buyer by entering into a contract of absolute sale. While in a conditional contract of sale, the fulfillment of the respective condition renders the sale absolute and affects the seller's title thereto, such that if there was previous delivery of the property, the seller's ownership or title to the property is automatically transferred to the buyer. Parties to a contract of sale: number 1, the vendor or seller. The vendor must be legally capacitated to enter into a contract. If the vendor is a corporation, the contract must be executed by the board of directors or by a corporate agent duly authorized by the board. The vendor must have a right to transfer the ownership at the time it is delivered. Number 2, vendee or buyer. The vendee must be also legally capacitated to enter into the contract. Persons who may not enter into a contract of sale: Absolute incapacity, meaning incapacity is absolute in case of persons who cannot bind themselves. Example, minors, insane and demented persons, imbeciles, deaf and dumb persons, prodigals, and those subject to civil interdiction. As their personality is restricted, they have no capacity to purchase and sell by themselves personally but only through their legal representatives, according to Article 1327. Note that in case of minors or other persons without capacity to act, the contract of sale is voidable. However, the purchase of necessaries is valid, for which they shall pay a reasonable price therefore, according to Article 37, Article 14.8.9. Persons who may not enter into a contract of sale. Relative incapacity. Why relative? Incapacity is relative when certain persons under certain circumstances cannot buy certain property. Example, husband and wife, sale by and between spouses. Special disqualifications of this are sale by and between guardians and wards, sale between agents and principals, and sale between executors and administrators of state of the deceased. Now we are done with the parties. Now, how about the subject matter of the sale? Number one, it must be licit. It is important that it must be legal. Number two, it must be a thing the seller of which has a right to transfer ownership of at the time of the delivery. And finally, it must be determinate, meaning it is particularly designated or physically segregated from all others of the same class. Additionally, it may be things having a potential existence or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract. In either case, the failure of the condition or contingency to materialize will invalidate the contract. Fifth, it may be a segregated or an undivided share or interest, and it may also be a subject to a resolutory condition. Our example is the object of a pacto diretto, meaning if the person who bought the object also resell it to the other person. That is what we call pacto diretto.